Your doctor was careless and caused you significant harm and injury, and now you decide to bring a lawsuit against him. After you file a lawsuit, you learn for the very first time that your doctor has a long history of being sued by other patients. And now you believe that you are fully justified for bringing your lawsuit because of the doctor's history. When your case goes to trial, will you be able to use that information about the doctor's history of being sued by so many other patients to the jury, so the jury can now hear this? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, this is a medical malpractice case. You believe that your doctor violated the basic standards of medical care, causing you significant harm and injury. You didn't know about his history of being sued by all these other patients over the course of his entire career. You knew nothing about that. You didn't bother to go ahead and do a search to see whether or not any other patients had sued him. You didn't bother to go online to check the reviews of this doctor to see what other patients had to say about him. You went on a recommendation, and based upon your evaluation, based upon the doctor's consultation, you decided this was the right doctor for you. And you know what? You felt great about it. You felt comfortable. You felt like you could put your life in the doctor's hands. Well, now you realize you were totally wrong. Now you kick yourself for saying, you know what? I should have done that. I should have read the reviews. I should have gone online and found out what was going on. I should have checked to see if the doctor had been sued before. Okay, so you didn't do that. And now you're in a situation where you now have decided to bring a lawsuit against your doctor. And now you want to know, can you take the doctor's history of being sued by all these other patients, it might be 5, 10, 20, or even more, and now show to the jury at the time of your trial 2 years later, hey, listen, my doctor screwed me up. And because he has such a horrible history, all these other patients agree. They also sued him. So therefore, you should give me a verdict in my favor. Can you do that? The answer is, in New York, no, you can't. You can't take all of the doctor's history of being sued, present it to the jury, and have them automatically link other patients' wrongdoing, other patients' lawsuits, to what happened in your particular case. Let me give you a great analogy. Let's say you're driving down the highway and you get pulled over for speeding by a police officer. And now the police officer checks your records and sees that you have 5 other speeding tickets in the same year. And now he says, hey, because you have 5 other speeding tickets this year, I'm automatically going to give you a speeding ticket right now. And you say, wait a second, officer, I wasn't speeding. He says, it doesn't matter. Your history tells me you're a speeder, therefore, I'm assuming that you were speeding right now. That's not fair, is it? You wouldn't want a speeding ticket in that instance just based on your history, especially if you weren't speeding in this instance when you get pulled over. The same exact thing applies in a medical malpractice lawsuit. A doctor might have 5 lawsuits against him in the past, maybe 10, maybe 20, maybe 30, or even more. And now you feel great that other patients have sued him, and you feel right that you, in fact, have brought a lawsuit against him. But guess what? You cannot use that information to show to the jury that what occurred in your particular matter was the same and that the doctor was careless in your particular case based upon the fact that other patients sued him and felt that they also were screwed up by his carelessness. So patients, once they learn this information, now they feel they could take that and use that at trial to show to the jury that this doctor really is careless. He's got a history of being careless. Well, you know what? You can't do it. And the defense attorney would be the first one to jump up and yell out, "Objection, Judge! That's prejudicial." And that would in fact be true. It is prejudicial because the moment the jury begins to hear that your doctor has been sued once, twice, 5 times, 10 times, 20 times, 30 times, now in their mind they get the idea, hey, you're not the only one here who's suing this doctor. You're not the only one who suffered injury claiming that the doctor was careless. So there must be some substance, there must be some truth if all these other patients are suing your doctor for being careless, causing them injury. And that could inflame the jury. And that could certainly affect how they view the case and how they ultimately reach a verdict. So if your attorney were to try and bring that information out, the defense attorney would jump up, yell out objection. The judge would be totally correct to turn around and say, objection sustained, which means no, you cannot ask that question. You cannot bring that information up. It is not appropriate. Now, I will share something else with you. Even though you cannot use that information about all the other patients who sued your doctor, you can't use that at trial. We can and certainly will use that during the course of negotiation if we have settlement discussions with the defense. The defense will already know this. They will know that the doctor has been sued many times. But I'll tell you something else. If the doctor has been sued many times, it gives us a very interesting opportunity. And why do I say that? It's because in each of those cases, the doctor may have already testified. So now we can actually go ahead and obtain transcripts of the doctor's pretrial testimony in those cases. And if those cases went to trial, we can obtain the trial testimony. And by reading prior testimony, it gives us a great insight into the doctor's mindset. It gives us great insight into the facts of that particular case. And then we see if there are pieces of information, things that he testified about that we can now use to cross-examine him in our particular case. So it gives us a whole host of great information that now we can scour to see whether or not we can use it in our particular case to show that the doctor said the standard of care for this scenario is to do A, B, and C, but in your case he's saying it's totally different. That would be great information to have at the time of cross-examination. So, although you cannot use this information at the time of trial, we can certainly use it to obtain information during the course of a pretrial discovery as well as during settlement discussions with the defense. You know, I recognize and I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.